Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Cody Hayward, decided October 24, 2024. Troutman, J. Defendant contends that his trial counsel was ineffective for failing to move to suppress the physical evidence recovered by police during the execution of the search warrant on the ground that the police violated the knock and announce rule when executing the warrant. We disagree. We have recognized that a single error in an otherwise competent performance may be sufficiently egregious and prejudicial as to deprive a defendant of the constitutional right to effective legal representation. People v. Keshner. See also, for example, People v. Watkins, People v. McGee, People v. Turner. To rise to that level, however, defense counsel's omission must typically involve an issue that is so clear-cut and dispositive that no reasonable defense counsel would have failed to assert it, and it must be evident that the decision to forego the contention could not have been grounded in a legitimate trial strategy. McGee. See also Watkins, People v. Espinosa, Keshner. That standard is not satisfied if the omitted argument was not so compelling that a failure to make it amounted to ineffective assistance of counsel. Keshner. We have stated that counsel is not ineffective when the success of the argument the defendant claims should have been made by counsel depended on the resolution of novel questions. Watkins, or when, at the time of the defendant's trial, there was no clear appellate authority supporting the argument the defendant claims that counsel should have made. People v. Singer. The United States Supreme Court has held that a violation of the knock and announce rule by police when executing a search warrant does not require the application of the exclusionary rule under the federal Constitution. See generally Hudson v. Michigan. Defendant acknowledges that no New York appellate decision has decided to the contrary, either by distinguishing Hudson, on the basis of the New York Constitution, or otherwise. Indeed, defendant concedes that the issue is novel. We need not and do not resolve the merits of that question on this appeal. We merely hold that the issue was not so clear-cut and dispositive that no reasonable defense attorney would have failed to assert it, and therefore defendant's claim of ineffective assistance must fail. Singer, C. Keshner. Our concurring colleagues' reliance on concurring and dissenting opinions in the Second Circuit is puzzling, for three reasons. First, no party to this appeal has argued, either before this court or the appellate division, that New York's single-error standard for ineffective assistance of counsel is irreconcilable with the federal standard or should no longer be followed. Second, the concern expressed in the concurring and dissenting opinions in both Rosario v. Ercole and the denial of en banc rehearing in that case was that the state standard could act to deny relief despite an egregious error from counsel so long as counsel provides an overall meaningful representation. But as our cases demonstrate, a single, sufficiently egregious and prejudicial error will constitute ineffective assistance of counsel, despite an otherwise competent performance. See for example Keshner. In cases decided after Rosario, the Second Circuit has repeatedly acknowledged that our state standard for ineffective assistance of counsel is not contrary to Strickland. Schomburg v. Superintendent, Auburn Correctional Facility. See for example Cummings v. La Valley, Brown v. Ercole. Indeed, in Rosario itself, Judge Wesley, writing for the majority, correctly reasoned that if a court misunderstood the New York standard and looked past a prejudicial error as long as counsel conducted himself in a way that bespoke of general competency throughout the trial, it would produce an absurd result inconsistent with New York constitutional jurisprudence and the mandates of Strickland. Rosario. The concurrence fails to demonstrate that the widespread misunderstanding of our single-error standard of which federal jurists warned in the nearly 15-year-old Rosario decision has since come to pass. Third, no such misunderstanding has occurred here. We have not relied to any extent on counsel's overall competent performance, which defendant does not dispute, but instead hold that counsel's single alleged failure did not constitute ineffective assistance because the omitted argument was not so clear-cut and dispositive that no reasonable defense counsel would have failed to assert it. Singer. Our concurring colleagues acknowledge that meaningful representation does not require counsel to raise every conceivable claim. but there is nothing to indicate that counsel's failure to seek suppression under the state constitution based upon a violation of the knock and announce requirement was sufficiently foreshadowed in existing case law. Defendant's legal sufficiency contention is unpreserved for appellate review, and we have no power to review his contention that the verdict is against the weight of the evidence. The trial court did not err in holding that evidence that defendant had completed an uncharged drug sale hours before the search warrant was executed was relevant to defendant's constructive possession and intent to sell the drugs found in the apartment during execution of the search warrant, cf. People v. Telfair. The uncharged sale occurred in the same apartment in which police subsequently recovered the drugs defendant was charged with possessing. To the extent defendant challenges the trial court's limiting instruction to the jury on that issue, he failed to preserve that contention for appellate review. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Troutman. Judges Garcia, Singas and Canataro concur. Judge Rivera concurs in result in an opinion, in which Chief Judge Wilson and Judge Halligan concur. Decided October 24, 2024.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law